All right, so my name is Hal Emelfarb. I'm General Counsel with National Lien and Bond. We had a little bit of technical difficulty. I'm not sure exactly what happened, but we're going to be presenting the program this afternoon. So welcome to National Lien and Bonds webinar. Today we have subcontractors, suppliers, a few GCs that are in the audience. If you have any questions in chat, please present them to us and we'll be happy to try to answer them. One of the most important things I think that I want to accomplish today is that National Lien and Bonds has been around actually for over 40 years. And in that time, I've been very fortunate to be able to be one of the attorneys and general counsels who's been helping companies like yourselves and helping you learn the steps to take to protect your receivables and to get paid. And in doing that, we're in a situation where we have a really exciting presentation today that I think you're going to enjoy. One of the most important things that I want you to take away from our discussion is that one of the most unusual situations that I've noticed is that we've gone in an industry in construction from people doing a handshake to basically completely the opposite, where everyone today has become a risk manager. And in doing that, you're going to learn about situations that are basically situations that are, hold on one second, someone said you can't hear. Hello? Hello? Can you guys hear me still or not? Somebody said they can't. Yes, okay. All right, hopefully you can. If you cannot hear me, send me a chat, but I'm a little confused there on the chat. Okay, anyway, so what we're doing is learning today how to do risk management and how we can really create a nice environment of the ability to provide you into a situation that you're going to be in control of your receivables and protect them. So one of the questions I have for everyone, and I'd like to kind of get your information, maybe you can respond by, I guess I can ask you the question here. And that is, if you look at your chat really quick, I start out with this question in every program. And I'd like to see what your responses are. When you're extending credit to your customers in the construction industry, are you today, I ask everybody in the chat, are you a secured creditor? And I'd like to see what your responses are. If everybody can just chat back, or those people that would like to, and say, yes, I am, or no, I'm not. And we'll come back to everybody's response in a minute. So what's the difference between being a secured creditor in construction and an unsecured creditor? The difference is that when you extend credit, you have some sort of collateral or protection in order for you to get paid. It's no different than if you buy a house, a bank puts a mortgage on it. If you have a business, they put a UCC lien on your equipment and your receivables and things of that nature. So what I'm curious to hear is whether you think you are a secured creditor or not. So far we have one answer from Blanca. Blanca, you're being very responsive. So as we get into the program a little bit, I like to see, come on everybody, take a second, just give us your answer. There's no right or wrong answer yet in this situation. We just want to explore everyone's background and find out their feelings. So we're getting some good responses. Chat's not usable, disabled. I wonder, okay. Let's see. That's probably my responsibility. Okay, let's see what's going on with chat. Show chat previews. All right, anyway, okay. So as usual in the seminars that we provide, Some people think they are secured creditors, and some people think they're not secured creditors. Most people think they're not, because a secured creditor gives you the impression that you have to do something to become secured. So in that situation where you find yourself, whether you're a secured creditor or not, the answer is, quite frankly, by law, you are a secured creditor if you follow the statutory rights of the state for which your project is in, through the mechanic lien, bond claim, or other legal remedies of that nature. But usually liens and bonds are the ones that get you paid, and those are the ones that provide you security. Now, how do you become a secured creditor? Typically, if you're going to like be a bank and ask somebody to put a mortgage on your house, which is what a lien does for you. You put a lien on somebody's project, somebody's building, someone's home, someone's office, commercial, liens on funds, schools, bonds, Miller Act claims, little Miller Act claims, public bonds for highway projects. How do you get like that? Well, typically to have a secure credit arrangement, you need to sign a piece of paper, and your debtor needs to sign a piece of paper with an agreement. But the special thing that I want you to understand today, the most important thing you can walk away with, is that you become a secured creditor when you basically sign a contract and extend credit and deliver labor and materials to a project. How does that work? You follow the mechanic lien or the payment bond laws or the liens on public funds. That's what we're going to be talking about today. So when you're in this situation, you're going to find yourself really looking for how do I protect myself? What steps do I need to take? And when do I need to take those steps? How do I get the help to find that out? And then you kind of go from there. So in the meantime, the situation is set up to really have a really good knowledge of what you need to do. So in that regard, you basically have a situation where you have to understand how the lien laws work. So we're going to talk today about the way lien laws work in general, and then we're going to get very specific. And then as I get information from the audience, what states you want to hear about, I'm going to surprise you a little bit with some information of what the lien laws look like. Now, why are we doing this? We're doing this because, as I said, in my experience in the last 40 years, I've never really seen, I would call this almost an unstable and insecure credit environment that I have a feeling is coming and is kind of upon us a little bit, even though it hasn't really hit us yet. The reason for that is money's getting tight, the economy is getting into a problem with the inflation, and people are beginning to get a little nervous. So we have to understand if we're going to become a secured creditor, what do we need to do? So let's look at this. When you're working in construction, the first thing you're going to see and understand is what is your role on the construction job. So who's on the job? Obviously, the owner, private or public. You've got the general contractor or prime contractor, then the sub, then you could be a sub, or supplier to a sub, or a sub and a supplier to them. So it's called tier coverage. This is important because the way all the statutes are created, all of the bond laws are created, kind of work like this. They work because you're extending credit on a project and you have a contract with somebody. So let's say you're a general contractor. Let me get the general contractor position out of the way, even though most people, I think today, are suppliers and subs. But this will help you understand what you're supposed to do if you understand what the general contractor is supposed to do. Because in effect, you're piggybacking, in a way, off of the general contractor's rights and certainly over his position and his contract. What I find quite interesting is when you're extending credit in construction, in this case, the general to the owner, you have a situation where the general contractor has made an arrangement with the owner, and in that owner situation, you're able to be in a situation whereby the owner has a loan with a lender, typically an agreement with the general contractor, and these documents together work side by side. So when an owner goes to a bank, he borrows money, that's the construction project funds. The owner then signs a contract with the general contractor to pay those funds. Now, how many of you, if you can, again, let me know in chat or something, how many of you have worked with programs in construction that are online? There's one that was around, that was created around 2006. I was actually one of the first users of that program. It's called Textura. I don't know if any of you have ever been in the Textura program, but that program works like an escrow where the subcontractors get paid from a general contractor who's working with an owner, and the owner sets up the program with the general contractor, and it's kind of like a payment system. So on that system, when the general signs an agreement with the owner and they set up an escrow, it could be through a title company or it could be through one of these Textura platforms. So I'm kind of curious to see, let's see if anybody here is involved with that information. Let me see. Okay, yeah, a couple people have worked with Textura. Yeah, GC Pay, interesting. So, you know, it's kind of fascinating to me because I actually was one of the first people that ever used that program. I've kept abreast of it a little bit, and it's got a lot of interesting features to it administratively. I'm going to show you a little bit of information a little bit later on another program that we're working with, designed more for suppliers and subs. This Textura program is basically for the protection of the GC and the owner and for the convenience of the subcontractor. It'd be nice if you'd be able to sign up to the program and have a situation where everything could be done like through logic. So anyways, getting back to the general contractor and the owner. So let me give you an example. In Illinois, we have a situation where this will kind of demonstrate how the loan and the owner and the GC work together, where by law, the general contractor must provide the owner with a sworn statement listing all the subs and suppliers that the general contractor hired. Likewise, if you're a subcontractor, in the back of your waiver, you sometimes have to put together, as you may recall, we'll see a form for that in a little bit, the subs and suppliers on your waiver. We're going to look later at a partial waiver of lien to date to show you some of the ways that these documents work together. But the reason for this is the owner wants to pay once. The general contractor, once he gets paid, the owner doesn't want to have to pay twice. And the liens, if the general doesn't pay a sub, is going to make the owner pay twice. So what are the requirements that an owner contractor has to enforce its lien rights? So this is pretty typical in most states. Notices are not required typically by general contractors or anybody if you're a subcontractor or a prime working for an owner. Generally speaking, you don't need a notice. Why is that? That's because an owner and a general are in privy to a contract. Let's say it's a $500,000 contract and they've been paid $250,000. Well, they know how much the money is because they're directly contracting with each other. Well, you might say, what about change orders? Well, they know that they have a change order. They know what their relationships are. There are no surprises. What the owner doesn't know, and this is where the notices are going to be required, where most of you are going to need to know what the notices are going to be, what kind of notices, when do they have to go out, and why. So if the general contractor and the owner know about each other, certainly they do not know, at least the owner does not, about who the general hired. So there are 5 subcontractors that the general hired, and those 5 subcontractors hired 10 suppliers. Then you now have an owner, a GC, 5 subs, and 10 suppliers. That's what the framework or the tier of the different parties are. The general doesn't have to provide a notice, but the subs and suppliers do, typically. So when do they have to do that differs depending on the state. For example, in Illinois, you send a notice out within 90 days from your last day of work. In Florida, if you're in Florida, you send a notice out within 45 days of your first day of work. In California, you send a notice out within 20 days of your first day of work. In New York, there are no notices for anybody to send out at any time, but you have to file your lien within 8 months. If it's residential, you might have to file your lien within 4 months. So we get all these different time periods there. And you say, well, I didn't have to do a notice in New York. That's good. I don't have to do anything. But New York law says you don't have to do a notice until 8 months to file your, you don't have to take any action, which is record a lien until 8 months in New York. But when that happens, if you wait long enough and the owner only has 10% of the contract remaining, and there's 30% of unpaid subs values outstanding, then all the subs get is the money that's left between the owner and the GC, which in my example right now would be 10%. So when you're looking at what you have to do, is you have to understand that typically GCs don't send out notices or are not required. Sub and suppliers are, and even though you have the right to wait, if you wait too long and you don't act quickly enough, you may be into a situation where you don't have full liens and you only have a lien for what money is left. So the reason that's important to send out preliminary notices, and in those states like Florida, California, Arizona, Washington, many of the preliminary notice states, Ohio, and other states, about 23 of them, we'll look at those in a little bit. What we have there is a situation where you have full price liens that you'll be able to collect your full price. And in other states, if the money goes out between the owner and the GC and there's only 20% of money left and 40% of unpaid subs and suppliers, you're going to have to share the money that's there. So you've got to kind of know in your state or states, if it's national, what the differences are and what are the best ways for you to take what steps to protect yourself. So we're going to look at some of these situations, but as we do that, the way that everybody should have a compliance program for themselves, and I want to show you this, is to be able to be in a situation where you have, let me just find this for 1 second. Yeah, here we go. Where you have basically what's called a claim, we call it a claim data sheet. It's your project information. So this is your name. Let's put down subcontractor. And the subcontractor gets filled out. I guess I'll just put my name down here to expedite the filling of the form. And then a preliminary notice or a lien claim. What is it you're keeping track of? Let's call it a notice. Who's your customer? GC. We can skip their name right now. What's the date of your contract? Let's just call it for today. Oops. Let's see, that didn't work. 09, 02. Okay. All right, we'll go back to there. Enter a valid date. 9/2. Enter. Oh, I wonder why this is 09. All right, something's wrong with that. I'm not sure what. Okay. Anyways, and then you want to keep track of your contract amount, how much money you're owed, say 75,000. And then you put down here, you'll need to know for your information, which you'll see in a little bit, is the project, let's call it commercial, or let's call it government for a second. And you put down your first day of work. And you don't know your last date, so you're not going to put it in. And then you have your project state. Let's do it in California. And let's call this a federal job. And your status is you're a supplier to a GC. Actually, let's go subcontractor. Supplier to subcontractor. Okay. Okay. And then you have your project information. Let's call this Marine Base Beach Harbor, and I don't know, San Diego. Okay. And then the owner of this would probably be, in this situation, the U.S. Navy. And we don't need the information there. GC, I don't know, GC. Sub, that's you. And so on. Okay. So there's a lot of information here. When you're done with all of this and attaching everything, because this is kind of really what you really need for a securitization of your project, you'd submit it. and it'll come back here, and then you would get the information from the person that you would be working with. In this case, we have National Lien Bond around the country and able to facilitate your ability to help get that done. Okay. So in the data sheet here, we have a situation where we're looking at a federal project and what your rights are going to be. So when you're looking at private construction, you have a mechanical lien. A mechanical lien is an encumbrance on property that allows you, like a mortgage, to be able to take a hold on the property like title, and you do it without a written agreement for security. It's given to you by statute, okay? So we went over a few minutes ago that if you're a sub or supplier, we'll go back to Florida, the first step you would take when you'd send your 45-day notice out from your first day of work, and you record your lien within 90 days, and you file your lawsuit within a year. Those are the three typical steps in a private construction project, whether it's residential or commercial. Send your notice, record your lien, file your lawsuit. In the state of Florida, it's unforgiving. And what does that mean, unforgiving? There's no leeway. If you don't send your 45-day notice out within 45 days from your first day of work, you have no lien rights. If you don't file your lien within 90 days of your last day of work, you have no lien rights. If you file your notice and file your lien, but don't file your lawsuit within 1 year of the time of your last day of work, you would have, or maybe the recording date, I have to check to be exactly sure of the lien, but within 1 year of either of those dates, you have no lien rights. But if you follow all of that, you're going to get paid, and you're going to be happy that you have a lien. I have a situation right now where this week, a paving contractor was working in Delray Beach, Florida, and he was working on what's called a subdivision improvement. So a lot of times in private alleys and places like that, or subdivision streets that are being built for the first time with subdivision improvements, he's putting in the base of the aggregate that goes underneath the alley in this case. And there's homes surrounding everything. And he came to us and said, I want to lien the properties. Well, you actually might be able to lien the properties with all the subdivisions and all the lots. But in this case, we found out it wasn't a project contracted between the developer and the general contractor, and he was a subcontractor putting the excavation work in the aggregate base. So the subcontractor, we found out, the city of Delray issued the contract to the GC. It was a public job, not a developer putting in subdivision improvements himself. And you have to understand the difference. Why? Because now we went from having a private lien, 45 days, 90 days to record, and 1 year, to a bond claim where you have a direct contract between a sub and a GC. Why is that different? So let's talk about the reasons we gave before. When you have a contract with an owner, you don't have to give a notice. Well, the same thing applies on a public job. Why? On a public job, if you're a sub working with a GC or a supplier working with a GC, usually it could be, depending on the bond, but rarely, you don't have to give a notice. In this case, our client that came to us last week had a $35,000, something like that, balance due after being paid $80,000, and the guy's not returning his call, the GC. He's not from Florida. He's from somewhere in Ohio or something, and he decided he just doesn't want to communicate with our client. So we got a hold of the city of Delray Beach. We got the bond, and we said, we're going to make a claim. Now, the claim is basically file your lawsuit within 1 year of your last day of work. You don't need a notice because you're directly in contract with the prime contractor. If you were a supplier to the subcontractor, like you were the gravel company giving our client, the excavator, credit, and your gravel wasn't paid for, you'd have to give your notice within 45 days, and then you need another notice, like a private lien is recorded in 90 days. A bond claim usually requires a surety company that you file what's called a bond claim notice in 90 days. Then you would file a lawsuit within a year. So the principles are the same, whether they're private or public, but every state's different. You'll see some of the detail, because I'm going to show you later a program that I wrote that is coming out pretty soon, the next couple months, that'll show you the kind of detail that you have to think about and the logic behind different state laws. I want to ask some of the people here, we're not going to be able to deal today with every state. We just don't have the time, but we have it online. If you look at our resource page at mechanicslien.com or paymentbond.com or milleract.com, we have that information and you can get that. And we're happy to provide this because we want to make sure that you're fully informed, that you know your rights. But before you know the details of your rights, I want to explain, as I've done, why you need and when you need and how you go ahead and perfect yourself. So if you have questions, we can maybe in chat, people can ask if you have some check. And let me check really quick if there's anything, because I see a few questions coming up here. Let's just double check. Let's see. Okay. All right. Okay. So far, we haven't talked about every state and about every step, but I wanted to kind of give you a little bit of background on that. So the way we basically recommend that you go ahead and operate your first inquiry with us or with anybody else, or even internally, is that you keep a job data sheet for every contract that you have, that you're working with somebody, or a project notice sheet, something of that nature. So you have the general information. I get a little bit more complicated because as an attorney, I look for more information because when I deal with people, you can look for less. For example, if you're in Florida, you would know, well, if I need a 45-day notice, we work with a lot of the notice services on there. Their sheet is about this long, 1 page. And of course, myself being a lawyer, it's more pages. Anyways, but a project data sheet, it will help you if you don't have one already, get the right form for your state. And if there's 50 states, we have ways to assist you in organizing that too. Or you might have good ways to suggest to us that we like to hear about as well. So I'm very curious to hear from you as to whether or not you have found other ways that you haven't heard from us today, and how to get yourself organized with spreadsheets today and computer programs. It's amazing. I mean, I wouldn't say there was only carbon paper, but there wasn't what we have today. Okay, so the next thing I want to kind of explain to you is that let's see. Okay, we just went through a discussion where we filled out the project data sheet on what's called a Miller Act case. So on a Miller Act case, that's a federal project. Now, here's the good news about everybody here in the audience. I don't know if you all or some of you do federal construction work in your business, but federal law applies to all 50 states, and it kind of demonstrates to me a really good understanding. So I'm going to make sure that you leave here today, number one, with an understanding of how this federal law works. It's called the Miller Act for the federal. And then in your state, it'd be called the Little Miller Act. Why is it called Little Miller Act? Because the federal government came out with bonds required for general contractors on projects, and then all the states followed. So the Miller Act is called Little Miller Acts for, like, let's say, I just mentioned Delray Beach in Florida, for the state of Florida or your state. So how this was set up in our program here that we work with after the information was filled out before, what state is the project in? Well, I filled out the form California, but we haven't entered that in the program. But here we have one that was Illinois. It doesn't make any difference in this case what the state is because it's federal. What kind of job is it? And what is your remedy? So what is your work? What state is your project in? What type of job, federal, public, or private? And then what is your remedy? In this case, Miller Act. Once you find your remedy, this Miller Act is a bond claim. On every federal job and almost every state job where there's construction over a certain dollar amount, in this case, the government is 75,000, other states it may be 30,000. The states are different. But in any significant public construction job, the general contractor bids on it, and he must put up a performance bond to guarantee the agency, public or federal, when I say public, state or local, and that particular contractor must put up a payment bond. So it guarantees the government that he can perform the job, and the payment bond guarantees you, the sub and supplier, if you're covered by it, which I've got to explain when you are covered or not, how you get paid. And then it provides you security. So you can extend credit as a secured creditor on every public or private job by watching your rights given to you by statute. So the Miller Act says the following. If you're selling a general contractor, you have to file a lawsuit, make a claim, and file a lawsuit within 1 year. Very easy, you have 1 year to take your action. Now, I wouldn't recommend, if you're in a federal job, waiting a year. If you're a sub or a supplier to a prime contractor, you have 90 days to send a notice from your last day of work and file your lawsuit within a year. That's regularly, but not always, the way it's done across the United States too. So don't look at that for every state, but generally it's, if you're working with a GC, no notice. If you're a sub or supplier, within 90 days. Now here's the catch. About half the states say everybody that sells on the project, they are covered by these bonds. Half the states say, well, we'll give you some coverage for some people, but not everybody. So let me demonstrate typically the difference, because the Miller Act, the federal laws, are copied in some states, and some states are much more generous and provide greater coverage. So let me explain what coverage means. If you fall within the right tier relationship, both the mechanic liens and bond claims, you are covered by the state law or the federal law. So let me go back to the federal Miller Act. Let's go back to the project in San Diego that we talked about when we filled out the sheet a few minutes ago on the beach harbor job. And let's pretend that we are a sub working with a GC. Yes, you are covered. That's tier 1. Let's say you're a sub to the sub GC. Yes, you're covered. Let's say you're a supplier to the sub to the GC. Yes, you're covered. Let's say you're a supplier to a GC. No, you're not covered, because suppliers to suppliers are not covered. Is a supplier to a subcontractor covered? No, you're too far down the tier. So the first tier, that tier with direct contracts between the sub and the prime, and the next tier between the supplier or sub and the sub to the GC, you're covered. But the third tier, you're not covered. So how do you get around that? We're going to look at some documents today that I hope to show you, or actually I may have to send them to you, but we'll discuss them, that show you how to get covered when the laws don't protect you. We kind of extend your rights, which I'll explain a little later. But I wanted you to understand that if you're doing a federal project, you're not always covered if you're too far down. So here we have a situation where, in this example, we have a federal job, Miller Act. The customer is the GC. Here's the bonding company. Actually, the customer here would be a subcontractor. Here's the bonding company, owner. I'm saying this is Air Force, architect, lender, and so on. Okay. So here we have a situation. This is what the project data sheet looks like when you fill it out. What's your contracts amounts? What's the project date? In this case, 8/31/2022. What are your documents? Here's a lien law summary that we have available in our program when we have it. And you'd upload for us contracts and invoices and last day of work. What are your deadlines? Well, if we're working as a supplier to a sub, which in this case we are, then we have to do our notice within 90 days of last day of work, and then we have to file the lawsuit within 1 year. And this is just a way to keep track of that. And what are the tasks? Call the customer to follow up, 9/29, which is a week from today. The other task would be by 11/29, send out your 90-day notice and file your lawsuit within a year and 8/31. So it looks like our last day of work was 8/31, 1 year from last day of work. So as a supplier to a sub on a federal job, you need 2 steps. If you ended work on August 31st, within 90 days, you would send your notice, a Miller Act claim, to the surety and contractor, and then you'd file your second step, which is the lawsuit within 1 year of your last day of work on the project. So that gives you some information on the way the coverage works. And this is an example of the deadlines and some of the program that we're working on here to provide information for you. so you can get paid. And here's this project right here, and this is how you would keep track of it. This isn't the exact one we were talking about, but this gives you an example of how to keep track of the projects. So one of the things I want to show you is a little bit here. This is a little bit, I don't know if you can all, let me make sure I make this a little bit bigger. Yeah, so you can see what's going on. Let's see. So we were talking about Florida a second ago. And we're just talking about, for example, Florida law and federal. So here we have a situation where Florida, just like California, same thing, send notice to surety within 90 days of last day of work, file your lawsuit within 1 year. So this is kind of when we start programming the data and the information for deadlines. This is, you know, the information that helps. So you enter your last day of work. Here's really the simplest thing, because I don't want to bore you with a lot of information. It's probably a little bit, a lot of information for some people. Some people may be familiar with this already, but here's how this works in a nutshell. Because I've designed for the last 20 years, when software came out, a lot of the logic that you see that's out in the country today, they came to us, they asked us to put things together. We've had our programs licensed out and working with people around the country. Here's how I looked at this when we developed the programs, and as we continue to develop them to help you make it easier to go back to your work and do your job, and let the software or some people like our partners around the country, which I'll explain, help you get paid and watch your lien rights. But here's how it works. The first question you would ask is, what state are you in? And in doing that, let me just see something here. Let's see, where did that go? Oh, here we go. Okay. So let me, okay, now you can see the screen. So in this situation, you ask yourself, what state is the project in? So in this case, we have Florida. Is it public, private, or federal? So you see the lines here, it's federal. What is your remedy? And then from there, you then know what are your dates that you have to put in. In this case, only one date is required to track your rights in federal. That's your last day of work. And what are the steps? Send a notice to surety in general, notice of bond claim. And then when is it being required? Well, within 90 days of your last day of work. Now, in your Florida Federal Miller Act job, on you entered your last day of work, in this example we had before, was August 31st. Your second step would be file a lawsuit within 1 year of your last day of work. So I just thought you'd like to see how this is done. It's kind of interesting. Then when we go to Florida, we now have a different question we ask. What state are you in? Is it public, private, or federal? What is your remedy? Well, in federal, it's Miller Act. In private jobs, it's mechanic liens. So now, what was the date you started work? Did you serve your notice of 45 days after you started work to the owner? Here. That's if you're a supplier or a subcontractor. Then, if you're a general contractor, and the next step for a supplier and sub would be, hold on one second. Hold on one, yeah. Well, the next step would be that you would record your lien claim. Oh, here we go. Within 90 days of last furnishing, and then you file your lawsuit within 1 year. So that's on private mechanic liens. Now, in Florida, here are the remedies that you have. If it's a federal job, you have a Miller Act claim. If it's a private job, you have a mechanic's lien. And in Florida, if it's a private job, you also might have a private bond claim. And on a bond claim, on a private commercial job, you still have to follow the 45-day notice against the surety and file a notice of non-payment, which is different than a lien, within 90 days, and file your lawsuit within 1 year. So the time periods are the same, but their actions are different. So now what we've seen here, and I think this would help you a little bit. What you see here is in Florida, whether it's private, public, or federal, the remedies are basically the same. Send a notice out, file a claim against the recorder if it's a lien, or file a claim with the bonding company if it's a public job, and then everybody files a lawsuit within 1 year of your last day of work. So Florida is a pretty interesting state, you know, and it's kind of nice to see. Let me just check if there's any more questions that anybody's looking for. Okay. Okay. All right. So I think that information is providing you with good background on having the ability to understand, you know, when you have to do a notice and what the steps are. Notice, record, or file a claim, or file a notice of non-payment, and file a lawsuit. Those are the 3 steps. Now, I talked to you a little bit about these things. Let me just see if there's a something else I want to share with you here. Yeah. The important thing that I want to speak about next is this. So if you're a supplier, or if you're a subcontractor, and if you're a GC, all 3 parties have different risks with their customer. The owner and the GC have a general contract that has risks. The subcontractor and the general contractor, now you have those risks. And then supplier to a subcontractor has more risks. So those risks are all different. We're going to see a little bit of information today. I hope we'll be able to talk about this, and I might be able to demonstrate. We'll see with a couple documents that I'll be able to send to you, that just because you have lien rights and you send lien rights out doesn't help you get paid by themselves if you're not careful to manage the risks that you have in construction. And those risks can be very expensive. One of the most interesting things that I have found is that we're in a situation where basically the contracts could be very simple. I'll give you an example. I just finished a case yesterday, and I want to talk about it generally. My client was a supplier of a certain kind of product on a state, the Northeast state, called Connecticut. It's not really the state, but I want to give away the information. Department of Transportation. And on that project, my client was asked to provide materials because the first person on the job refused to provide them due to the recent supply chain interruptions. Why? Because the subcontractor placed an order, but the manufacturer, in this case the supplier, was unable to perform. It's not a surprise in the last year, and with the pandemic, and then the inflation, and then all of the supply chain problems and the weather problems, it's not unusual that you might find yourselves in that situation. So my client, who was the second supplier, got a call from a sub and said, I'd like to buy materials from you because the other guy basically can't provide the materials on time. What do you have to say? So my client, the supplier, thank God, managed himself very, very well. He didn't do what a lot of people have with a lot of terms and complexities. He basically had a purchase order that said he will follow the spec of the quality of the project for a Department of Transportation job, and he will go ahead and sell the materials to you, but he does not guarantee price for more than 60 days because of the fluctuations. Surprised he gave 60 days with some of the fluctuations, but he did. Then they asked him what kind of schedule he had. He said he's going to try to do within a couple months, gave a general number of months, but he really couldn't guarantee it. So what does that contract look like? It's a purchase order with a price that says it's only good for 60 days and does not include a deadline for when the materials have to deliver. Now, it's understood between merchants that you have to be reasonable. That's the Uniform Commercial Code. It fills in the forms of the terms for you, when the Uniform Commercial Code, when you don't fill them in yourself. This is like the simplest contract you've ever seen: a purchase order between the seller and the buyer, the amount of money for 60 days, and it talks about specifically what that product would be in detail, because that had a spec. And in that spec, it was adopted as between the state and the contractor, was incorporated into the purchase order. But that was only for quality. It wasn't for price, it wasn't for scheduling, but it was for quality and test and quality control. Now, the unusual part about a public job is that in a private job, you have architects and engineers that are basically out there that are third parties. But on a state highway job, particularly, the departments of transportation have their own resident engineers. So while our client didn't have any specific clauses, let's say, about certain things, it's obvious that the only person that could approve the engineering in this job would be the resident engineer of the state. And in fact, that's what the spec said. The resident engineer, not anybody else, could do it. The subcontractor bought materials. The reason they came to me is because they weren't getting paid. We took almost $1 million and some dollars, and the client was able to get about $700,000 to $800,000 in negotiations, and we got down to the last couple hundred. And then the subcontractor goes, "You didn't design this correctly. You didn't deliver this on time. You charged me too much money." Well, okay, in this situation, none of those provisions were provisions that would be controlling, because that wasn't what was in the contract. The only thing that was in the contract was a 60-day term, and the manufacturer was able to get the subcontractor to agree to amend with purchase orders the price changes. Then they said, okay, well, I guess I got to pay you that amount, but I'm not going to pay you for your material because it doesn't pass the test and it didn't get here on time. Well, lo and behold, they're wrong. The contract was not requiring a specific deadlines. When it doesn't require specific, you have to be reasonable. And if you're going to be enforcing something, you have to provide notice, none of which the subcontractor did. Because the subcontractor, frankly, was trying to get out of all those increased prices that they agreed to and increase the project from 800,000 to $1.5 million, let's say. Then that was the way they're going to play the game. So I mention this to you because what we're going to see and we're going to talk about now are subcontract terms for suppliers, and we're going to talk about some of the terms for subcontractors. And when we talk about these terms, you're going to see what the risks are, because these are real risks we deal with every day, not hypothetical. I've written treatises on construction law, on termination law, on change order modification extras. It was quite educational when I was a young lawyer, writing all these books and articles. But it was nothing like really sitting down like we did the other day when we went to mediation on these subjects that we just mentioned. How do you fill in contracts that don't have terms? And what happens if you have contracts with terms that are really onerous? And why would you want to sign those kind of things? So I started out this program earlier and mentioned to you, and I want to just reiterate that the reason why mechanical lien and bond claim rights are helpful to you is they give you security. And I want to give you a philosophy that we have in a minute about how you exercise that security to protect you and how you negotiate through the claims process. I think you'll be interested in hearing about it. So in that regard, the clause that I want to talk about in a little bit, but I want to explain what was going on yesterday, is that we were not in court, though we had previously filed with the Department of Transportation a request for a bond. They gave us a bond. We're a supplier to a sub to a GC. Now let me ask questions. I want you to see if you can remember. I hope you're still awake. Okay. Are you required as a sub to a GC, a supplier to a sub to a GC on a public job? Are you required to give a notice? Yes or no? So let me wait a minute and see what the chat says. Somebody's got to answer, a couple people. Yes or no? Does a supplier to a sub to a GC in a public job making a bond claim have to give a notice? Peggy, you're there again. Blanca, thank you. So far, we got 2 right answers. One more person has to respond. Let's see. Yes, you have to give a notice because you don't have a direct relationship with the general contractor. Very good. So we filed a notice against the bond, and guess what else we did? We sued because you had to file your lawsuit within 1 year. So in this particular state, let's call it Connecticut. It's not Connecticut, so I might be off, but in this particular state, by Connecticut, you had to do your notice within 90 days of your last day of delivery, which in this case was September of last year. And then we had to file a suit within a year. So guess what month it is? September. Guess what we had to do? File a suit. We agreed with the subcontractor and the general and the bonding company that once we filed, we would then go to mediation. And the reason we would agree to do that is because litigation, with which if you haven't experienced it lately, is so expensive, you'd never want to be there, even though you have to be sometimes. So here, we filed a lawsuit and we never spent a minute in court because what we did was we agreed to mediate. And so when you're looking at subcontract terms, which I want to show you right now, let me get some subcontract terms for you. Okay. Let me make sure I share my screen. Okay. Hopefully you can all see this right now. Let me make it a little bit bigger. Okay. So here's your typical situation. If you're a subcontractor or sometimes a supplier, you receive a purchase order from a sub or a subcontract from a general contractor. You know what it says? It says the following. Here's the work I want you to do. Here's when I want you to do the work by. You must do the work by this date. You must do the work for this price. I have a right to change the work, but you don't have a right to stop work. When I get paid, I'll pay you. If anything goes wrong, you're going to hold me responsible. And I won't give you anything extra, even though I ordered it, unless it's in writing. And even then, whatever. I have the right to terminate you at any time or for default. If there's a claim for insurance, you're going to defend me and indemnify me. And if there's a situation where you know you're late, I'm going to hold you responsible for all the delays. And if you don't like the site when you got there and it was concealed from you, too bad. I ask you to look at all that. So in other words, everybody is putting the risk on everybody else, and no one is being reasonable, acting in good faith, and being responsible if you look at the documents. Now, you are probably struggling with editing these documents, many of you, and working in this direction. So let's take a look. Let's take a look at, okay, here's the simplest way a subcontractor or a manufacturer can basically take terms that are against you and turn them around. We'll be sending this information out to everybody. You'll see it. So here's a rider to your subcontract. Okay. First thing we say is our rider, this is your rider, supersedes the terms of the contract. We then say, hey, if you got better terms you gave me with the owner, or the general contractor, I want those terms. Notwithstanding anything in your contract you gave me, which is like the most one-sided contract you've ever seen, okay? I'm not going to agree unless you gave me copies of the terms you want me to be bound to, not incorporated in writing so I can see what applies to me. If there's any conflict between terms in the event of a dispute, you know, my terms apply, not yours. Somebody asked earlier in this program in the chat, can you force me to waive my lien rights up front? Well, if you have this rider as a matter of contract, you're going to say any provision where the sub waives its rights, okay, on provisions is void, okay. Prior to receiving payment is void. For some reason, we have to put. Let me quickly edit this term to make this clear. Wait, hold on. Not only is it void, but even if they ask you to do it and is against public policy. So in most states today, we have a list if you need to see it of the states. But like in Illinois, New York, Florida, I think California, probably like 3/4 of the states that pass laws that said if you want to waive somebody's rights, even if it's in the contract, it's against public policy. Then if a claim says I'm waiving any claims for delays or damages, okay, you know, why would you do that? Just because they're asking for it, you say, no, if you caused me to be late and it wasn't my fault, I'm not liable and you might be liable to me. So if you ask for work prior to receipt of a change order, well, if you're asking me, I don't need a change order because you required it. And the law says, anyways, if I do work and you later pay me for the work and you didn't give me a written change order, but a verbal change order, and you paid me for the work or at least offer me a change order later, that means I don't have to get a change order before I do the work because you waived that right. And subcontractors will say, well, I'll pay you, okay, but after I get paid, but I want to make sure you pay your people before you give me payment. So that's not something that you want to get yourself into. We have a situation today. It's very strange. I was on the phone earlier today with a cabinet manufacturer. He said to me, he did a dormitory in New York on a public job, and the subcontractor and the general, he sold the general contractor. A lot of times cabinet guys will sell the general directly. He got paid from the university in the state of New York, and the guy didn't pay him. And New York has a trust fund law. So if the state has a trust fund law that the money that the general got, he should have paid within 14 days under the prompt payment laws. And if he doesn't, he's personally responsible. So these are riders here which talk about the various provisions that you don't want to get yourself stuck in. So here's a clause which says any provision where a subcontractor is bound by arbitration, litigation, or other dispute, unless the sub is permitted at its own expense to participate as a party, okay, is also void. And we're not responsible for the fees. So in that regard, you know, what do you want to do? Do you want to litigate? Do you want to arbitrate? Do you want to mediate? Do you want to mediate first and then arbitrate? Or do you want to first mediate and litigate? Or do you just want to litigate? So you've got to look at these clauses called ADR, alternative dispute resolutions. And they say, well, I find them kind of boring, but lately I've kind of liked them. One of the things I want to explain to you is after being in this legal profession, helping people like you for 40 years, I found a lot of different ways that people try to get things done. So I mentioned to you this, one of our clients yesterday when we were involved in the mediation. So guess how much the mediation cost? Well, remember what we did. We're a manufacturer. It's a DLT job. We sued the subcontractor. We sued the general for unjust enrichment, and we sued the bonding company. So there are a sub, general, bonding company, and we're the plaintiff. Okay, where we sued for a couple $100,000, those people and the bond, and basically there's four of us. So the four parties agreed to mediate. Well, even though we're the plaintiff, they're the defendants. Strangely, but thank God, our office in this state in the Northeast was able to get, with my direction, 1/4 of the responsibility for the cost of the mediator will be paid by us, and the other parties will pay their equal share, one quarter each, the four of us. So everybody is paying 25%. So today I was talking to other lawyers and said, guess how much my client had to pay for a mediation that lasted an X number of hours, 5,000, 8,000. I go, no, my client paid $345. How could that be? We did two things. The mediation was supposed to be all day. I said, no, I don't think it's a good idea to mediate all day because I've never been in a mediation because nobody listens to the mediator until they want to listen, which is when they want to leave. And when they're done talking and they're tired, then people get reasonable. So I've been in many, many mediations. Maybe you have too, but if you haven't, please take my advice. Don't get frustrated. Don't start early, and don't leave the mediation until the very, very end, because you'll have an 85% chance of settling at that point. So I said, we're not mediating at 9 o'clock, we're going to mediate starting at 12 o'clock. So we cut the cost of mediation in half by getting in the afternoon, and we cut the mediator's cost by 4 instead of by 2, because we had 4 parties participating. Therefore, the mediation was $345 because we basically, the mediator only had to spend 4 hours, and it cost them 4 or 5 hours, around $2,000. So we spent roughly 25% of that amount. So when you're looking at these clauses, you go, I bet you none of you pay attention to that. So I strongly would believe that you do not want to litigate, and you must look at the alternative dispute resolution. And we'll be talking and sending you information on some of the clauses. I don't want to over emphasize too much about one clause today, because we'd be here for a long time. We only have about 15-20 minutes left in the program. So I just wanted you to understand, though, every one of these clauses really are helpful. There's another clause in here which is very expensive and problematic, and I want you to be aware of it, and that's called indemnification. So what happens in indemnification is, let me just see if I have the, in this draft, the indemnification's in here. Let me just double check. No. Okay. This is designed more for supplier and subcontractors without indemnification clauses, but indemnification clauses can be very expensive. If you indemnify as a subcontractor, particularly a general contractor, they're gonna take you for everything you have, and you better have insurance, because if you don't, they're gonna ask you to pay their legal fees, and they mean it, and they come after you. So you got to be very careful that your indemnification clause, if you have one, which I prefer you not have to sign, but if you do, specify specifically that you are indemnifying them, not for everything, but only if you are your negligence or your violation of contract. And if you limit yourself a little bit to that, thank you, Jennifer. If you limit yourself to that, you're in a better situation than if you have a broad form indemnification. And then the other thing is, you've got to be careful, because if you are in litigation, generally, I just want to give you a risk management tip. Make sure when you get sued, unfortunately, if it ever happens, and I don't wish it on anyone, is that you end up providing your carrier with a copy of the policy, and hopefully they'll represent you. And if they don't represent you, they may reserve their rights. Then you can hire a lawyer to represent you, and they still may pay for the defense. So there's a whole way of dealing with defect claims or lawsuits that come up. And if you ever need help with that, I'll explain a little bit why we're able to help you with some of those things. Anyways, so do you want to sign liquidated damage provisions? No. Do you want to be responsible for delay? No. You've got to be very careful on what you're signing. What happens if there's a default? You know what? We better have a provision in your contract that says, if there's a default, I want to know about it up front, because I don't want to be litigating it, and I want an opportunity to cure it, and then you have it from there. Same thing with termination clauses. Can you be terminated? 2 ways. Well, there's 3 ways. First way is they claim a default, you didn't perform on time, or you didn't pay somebody, or you did your work incorrectly. They're going to make a demand for you to be defaulted and maybe terminate you. That's why you need this opportunity to cure clause to offset that. The second thing is that it's a material default. They'll write in almost every contract in government by law incorporates this, because you can't bind the government to anything if they want to get out of it, because they're the government. So they have a termination by convenience, which means anytime they want, they can end the contract and pay you for your expenses and maybe some profit. Private sector contracts all have those clauses in there now. You got to be careful about that and make sure that you're covered for the cost up to that point in time and some profit and overhead. Then the third kind, other than material breach and termination by convenience, I learned this as a young lawyer. Here's the best way to terminate: by agreement. What does that mean? Let's make a handshake and get out of here with an understanding. I don't really want to spend a lot of time with lawyers. I may need somebody to help me, but I would like to resolve this. And that's the third way. That's not written into the law as far as in your contract. That's just common sense. So a lot of what we're learning here today are the specifics of legal statutes for notices and bond claims. We're getting to a little bit of exposure on how to offset some of the contract provisions that I mentioned to you before, the ones where they say do I have to pay you promptly? Do I have to pay you conditionally? Do I have to pay you when I get paid? Do I have to pay you for extras? All these kind of things. So if you have any specific questions, now's the time to ask, because we're kind of coming to the end of the program in the next 10 or 15 minutes. And I just want you to know this risk management is important. So I wanted to tell you that how I developed a program in my head. I think I'm a pretty good lawyer and a judge of character, but there's a lot of great lawyers out there, and I've worked with many, many of them for the last 40 years. Actually, I've worked with 588 law firms, and I have that in my database because I actually hired them. 588. I've worked with lawyers that are bankruptcy lawyers, government lawyers, subcontractor lawyers, bankers, bankruptcy lawyers, all different kinds of lawyers. And I find that lawyers and the rule of law is what gives us in America the edge and why we're a great country. I don't want to be like giving speeches, and I don't want to be a red state or a blue state because all those colors can go away. We are in America with the rule of law advantageous to other societies that don't have it. We're advantageous to ourselves when we can exercise it. Now, the rule of law is not to be punitive. When I'm talking to the Department of Justice today. My client's an Afghan contractor who lost millions of dollars in 2014 when his government contractor he's working with went bankrupt. I had to find a way, which I was able to do thanks to his ingeniousness, where he was able to get the government to pay him from a different bank account than the general contractor's account. And the federal court so far have said, yes, you don't have a contract, Mr. Emilfire, with the government, but your client created one when he had the government change the bank account. So you can come in here and sue the government when everybody in the government says you shouldn't be there. So today I'm talking to the Department of Justice, to the attorney, and we have a very cordial relationship. And I talk to him like a human being because he or she at the Department of Justice are human beings. And I wanted to convince them that, we should be talking to each other as people under the rule of law to protect us. So if you have the rule of law and you can use it for you, this is what counts. You have lien rights and you have bond claim rights, and you now become a secured creditor. That means you have collateral. That means you have something that you wouldn't have otherwise. Why is that important to you? And let me see, before I answer that, let me just see if there's any questions that I should relate to this answer that are coming in. Okay, let's double check. Okay, good. We have some good questions here. So let me answer why this is important to you with some of the questions that were being asked. Someone is asking, we're doing apartment buildings, homeowner associations, and property management companies. Why are they asking that? Because those entities are not owned by one person. They're actually an association that controls and manages condominiums, numerous units. So if you're a 100-unit condo building and you go ahead and let's say you put in the carpeting in the hallway, guess what? You can't lien usually, at least you're not supposed to, the common areas. And I don't know if you lien or not the units. What I usually do is I come up with a way to conceive a solution, because a condo comes from a declaration of a piece of property, and from that people's rights, it's kind of like a vertical subdivision. It's not like 10 lots, they say 10 apartments, condos. Each one of them are combined by a declaration. And so when the developer files that, he's created 10 units controlled by a management association. So we would say if you did the carpet in the building and there's 10 units and you have $10,000, I would lien 10,000 and allocate 1,000 to every building, every unit in an allocation. Now, every state's a little different, so don't take this in every situation, but that's how I think, and I try to make those things work. And I work with attorneys across the country, which will answer the questions that are experts in the area that we team up with. What happened was, just to give you some quick background, when I was like 37 years old, I came up with the idea to put one lawyer in every state, summarize the lien laws. Hey, back then there was no internet. So I basically created a publication format that the ASA adopted for the 50-state program. The NACM already had something, and then we were working with many, many other associations in doing that. So in putting one lawyer in every state, somebody called me from New York, a young lady. She sounded young, but she represented a lot of declarations. She goes, am I right for your program? I said, well, I'm not really looking for decorators. I understand where you're coming from. Are you a member of the American Bar Association? Here, I'll put this up here. Let's see. This is the American Bar Association Forum Committee, which is something I've been a member of off and on for the last 40 years. And fantastic attorneys, very serious. They're wonderful. So most of our lawyers have an affiliation with the ABA Construction Law Division in the forum. And it was so great to see the expansion of so much diversity going on. But they emphasize diversity of equality, which is really good, and the rule of law. I'm getting back to the rule of law because that's very important. So in the situation here, about condos, you have to understand that when you file a lien in a shopping center, like I just settled a case yesterday. It was in Florida. It was a fitness center. My client's a low voltage contractor who did work. He filed a lien against a retail store where the exercise company was doing it, and who had a lease with the landlord. And in the lease, it says no liens allowed. Somebody asked a question before, can there be no lien contracts? Well, there can be, but we work our way around it. I said, I'm not leaning the real estate. Okay, I'm leaning the leasehold interest. So I'm leaning the lease that the tenant has, not so much what the landlord has. Yes, it's on the landlord's title. Well, too bad for you, but it says lien on the leasehold interest. We had another situation where we've done that, where people are doing business with different recreational parks and equipment like that. And we represent some of the largest like sports companies and people that work on private-public partnerships. Airports are like that. The government owns the property. You can't lien property. So the question about what is a condo, you have to understand what is it, private, public, or federal, house title held, and how does that impact the ultimate lien? So the idea is if you have the understanding of the law, then you can take the idea of secured creditor relationships where you can extend credit with security and come up with a negotiation formula that I developed after I put this network together. Because I like to negotiate solutions and I like to do it from strength. And I was taught by Herb Cohn, who was a really, really good negotiator, very strong negotiator. And I came up with this formula. Here it is. Transaction, which is your contract. We talk about risk management, plus power, which are your mechanical liens and your legal rights for collateral, equal what? Equal payment. That's why National Lien and Bond was created. It's getting people like you, to basically understand you have rights and you have remedies and you have defenses to what people are saying. And it's important for you to be able to exercise that. To exercise your rights and remedies, the rights of contract, thank God the Constitution protects, the statutes that the legislators put together and Congress between the federal law, the Miller Act, and the state laws, the mechanical liens, we must protect these rights. And how were these rights created? Does anybody know? Does anybody know how the first mechanical lien right was created? Well, okay. So how rights are created and when mechanical liens was like this. In 1787, the United States passed the Constitution, which we have today. In the Constitution, it said one day we're going to have a federal city. It's going to be somewhere in America that's 10 square miles. Nobody knew where it's going to go. Then in 1789, the first Congress met. And one thing I have to tell you about the first Congress, the first act of the Congress, Senate and the House of Representatives, guess what the act was? The first one the same. And it's copied all over the world. Our forefathers were geniuses. You'll hear about how they created the first Mechanical Lien Act. But before that, they said that if you're going to create legislation, and you're going to be an officer of the Senate, and you're going to be officer of the House, you must take an oath. Somebody said originally to a religious figure or God. No, to the Constitution of the United States. Because the Constitution has all these laws and the framework, as you know, I mean, we're having some discussions about these things today and why they're important. And so the Constitution requires you to basically act with certain kind of limitations of power, not to act beyond it. And the oath of office as a senator, a judge, anybody in the state or federal governments, a House of Representatives, department heads, and so on, they have to take an oath of office. You see the president and Supreme Court justices, take the oath of office. This is important because they're bound themselves by law. So when we're dealing here in contracts, we look at the laws and we look at the express laws of the contract and the implied laws in order to help you. So when you take transaction plus power equals payment, how do you get paid? You get paid because you know your rights. And if you need help, people can help you get your rights, whether it's our organization or the many other good ones that are out there. We understand today what our lien laws are. You have prompt payment laws, you have trust fund laws, you have laws of basically when you have to pay. Many states today have exact deadlines. If the owner's got to pay the GC, and the GC's got to pay the sub, and the sub's got to pay the supplier. It's very unusual, but it's out there. It didn't exist when I first started practicing back in 1977. By 1985, 8 years later, I was able to put together through the ABA Construction Reform Committee and other lawyers that I met across the country, a simple network of attorneys. They summarized the lien laws in all states, the bond claim laws, and they also put together in the last, 40, 45 years of my career to help me help my clients get an understanding of really how strong they are. We had a situation the other day in Louisiana. We had another one in Maine. We have one in New Jersey, Florida, all across the United States every day. I've got this situation with the federal government in Afghanistan. How do we solve the problem? We do it because we use transaction plus power equals payment, and we develop the legal team that needs to be done, big or small, and the people out there to help. So our legal network, the National Lien and Bond Network, consists of one lawyer in every state, and it consists of bond agents and people that help us, make claims, and it also notice companies. We have the greatest notice companies in the United States, and we don't do everything here from our office in Chicago nationally. We believe the local provider, who's a professional, teams up with us. So we've got a really great program coming out. We've got some really interesting things. Let me just check on one more thing on the questions before I close out, because I want to thank you. Yeah, you're going to get documents. I'm going to be sending information out to everybody that I think you're going to like. And okay, so someone just asked you about bankruptcy. And then someone else is asking about insurance and getting claims offset. So it's hard to say specifically, but bankruptcy, I have a situation where we have a client that built a hotel. He was actually the same company that had the bankruptcy in Florida, had another bankruptcy in New Jersey in the hotel when the pandemic hit and all the hotels filed bankruptcy. We had to go to Texas where the bankruptcy occurred, a large company that was bought by a hedge fund and merged a lot of other little companies into it. We went to bankruptcy. I filed a lien. They tried to put me in violation of stay. They threatened me with all this kind of stuff. We know our way around. We got the judge to give us permission to leave the bankruptcy. We foreclosed in New Jersey, and we got our client paid like 80 cents on the dollar. We could have gotten more, but it would cost us more to fight. So we ended up settling. But in bankruptcy, most people give up. So yes, if someone files bankruptcy, if you have a lien, and even if you don't, there are certain rights that you can get. Sometimes after they file, you can do certain remedies within 10 days, and you can also file your liens most of the time after the bankruptcy is filed. Not all, but most. And then when somebody's suing you for like construction defects and things like that and claims and making all these allegations, you've got to really sort that out and have an aggressive strategy and really look for experts to help you. So what I want to tell you is that the stories and the situations that people like you have given me the opportunity to present to other people to get them paid, and when I'm talking to general contractors and people, and I've done a lot of development myself in different projects that I've worked on and all kinds of different things. So I know the way around. The people we work with know our way around. They're very experienced. We're looking, if you have people that you like as lawyers, people that are good notice companies in your location, people that are good experts and consultants, we like to hear about them too, because we're ever growing and we're legally teaming and we're constantly expanding to look for ways to help you have your strategy of transaction plus power equals payment and have the tools and resources available to you to get you paid. We're coming out with a new program in the next 45 to 60 days that is going to be fantastic. You'll see some information on what we have now. We look forward to answering more of your questions as time goes on. And I want to thank each one of you for coming today and appreciate your participation. Feel free to contact us and I'll be telling you how. And again, thank you for spending your afternoon with us. And I hope this has been helpful. Have a nice day.